So these are non-violent offenses that he has previous convictions of. The hit and run's totally irrelevant, Your Honor. My client, all these cases the state brings up, what the state failed to point out? My client's never missed a court date. Not once did he ever have a failure to appear. The issue is flight risk. And if we're assessing that, he's lived in Georgia his whole life. He's had prior burglary cases where he showed up to court. He even showed up to answer to his hit and run. So he's not a flight risk. He's not a risk of intimidating any witnesses because the two most important witnesses for the state are on the run. The victim, we don't know where she is, and the guy who actually says he committed the murder. And by the way, when we talk about Mr. Abote, who's on the run, Your Honor, I want to specifically point out to the fact that evidence that we do have in discovery is that Mr. Abote goes out.
Objection, Your Honor. Objection. Attorney Apt is getting into the facts of the case.
Well, the whole argument has been about the facts.
He does that all the time in bond.
And I sustain that objection. Mr. Apt, I think you've primarily argued the facts of the case, and I understand why, but the state has objected, and I have sustained that objection.
Okay. Well, if we look at just the Ayala factors, and I'd like to point out to the court that every bond hearing I've had in 29 years, the state only argues the facts when the defense lawyers argue the Ayala factors. That happens all the time. But if we just look at the Ayala factors, Your Honor, my client has no convictions relating to anything violent. He shows up for court every time. He's not a flight risk. He's lived here his whole mental life. He's in severe need of medical attention, which I've brought to the court's attention, and I think that's deserving of a bond. Thank you.
All right. Thank you. First of all, I'd just like to say to Mr. Apt and to Mr. Reynolds and to the state that I have no problem with bond reconsiderations. There are rules that govern bond reconsiderations, most notably a change in circumstances, but time passes and things change, and I have no problem re-looking at these incredibly hard decisions that the court makes. So I do understand that there does need to be a legal showing of a change in condition, but we've heard this, and so there's been the allegation of the change of condition, most notably medical, and I'm sorry about that. The second one is with regard to medical attention, I'm happy to become involved if that's the issue and if that's brought before me, Mr. Apt. I'm not trying to ignore it. That is a jail issue, and again, if I can help, I'll be happy to. And then finally, and I do think that this is something that will come up soon because the co-defendant has a motion for out-of-time speedy trial, which we are getting on a calendar, and so we'll hear that shortly. I'm happy to get this case tried as soon as we can get to it, and we're ready to go. But insofar as arguing the strength of the state's case, I agree it's not an Ayala factor. These are difficult decisions, and motion for bond consideration is denied. Thank you.
Your Honor, since you've invited us asking for your help, then I specifically, and I brought it up, I specifically would like Your Honor's help then, because we're going on almost a year, and Mr. Reynolds is in daily excruciating pain. And rather than having the family go out and hire some civil rights lawyer and sue the county, which I don't think is necessary, I'd like an order instructing him to be brought to Grady immediately to be assessed for surgery.
Prepare the order, give it to the state, and copy the state. And if that's something, again, that is appropriate, I reiterate, I am happy to help.
Thank you.
Thank you. All right. Thank you, Mr. Reynolds. Okay.